Well, welcome everyone to this live stream session. Thank you so much for joining me. My name is Lior Samfiru. I am the employment lawyer. I'm one of the founding partners of Samfiru Tumarkin LLP, and I am here live right now to answer your questions about employment law, about workplace rights. This is my first session, live stream sessions for 2025. Couldn't be happier to be here. I enjoy doing these. You'll see me here every week, and you have the opportunity. You have me for half hour answering your questions live right here. Take advantage. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. You can find our firm across Ontario, BC, and Alberta. And right now, this is your time. This is your place to make sure you get answers about workplace rights. Maybe you're not having the best of a week at work. Your boss give you some sort of an ultimatum. Maybe you've been told that your job is changing. Maybe you've been told that you're losing your job. In all those situations, you have rights, you have entitlements. There's things that you can do. There are protections that you have. And the best place right now to get answers and to understand what this all means is just to type in the question. Hit enter. I will see that question. I will read the question and I will answer it. It's that simple. That's what you got to do. So take advantage. Don't be bashful. Don't be afraid of asking questions. There's no bad questions, only answers and solutions. Now, before I get started answering questions, let me give you some contact information. If you want to connect with me and my team when I'm not here on live stream, when you want to have a private chat, so easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that address on the screen. And when you're there, you'll get the phone number to reach me if that's what you want. The email address, all there. You can fill out a form and we'll call you. Everything you need is right there. And when you're there, if you want, you can also learn that much more about employment law. We have information, articles covering pretty much every topic you can think of. So employmentlawyer.ca is your one-stop resource for anything and everything employment law. But right now, you don't even have to worry about that. Right now, I'm live, right here with you on social media, on live stream, answering your question. So ask your question. Tell me what you want to know. If you've just joined me, Lior Samfiru, that's me, the employment lawyer with Samfiru Tumarkin LLP, and I want your question. I'm going to start answering them right now. As you're listening to me, type in your question as well. Get it answered. Don't leave here today without having your question answered. All right, let's get started. What do you say? First question today. Thank you. Nice and early from Ocean Breeze 22. Ocean Breeze 22 says, an employee applies for a medical accommodation that is a minor shift adjustment. Can the employer reject it if they say that the employee usually arrives late and or leaves early? Can this be considered undue hardship? So I'm not sure exactly what you're saying here. Are you saying that this employee tends to not show up for work on time, or there's something else? Here's what I'm going to say. An employer has to accommodate, okay? If you have a medical condition, a medical restriction, and it's supported by a doctor, your employer must accommodate. They have to provide those modified duties, the modified hours, maybe change your job, let you work from home, reduce your hours, whatever it is that your doctor says you need because of your medical condition. It's only when it's extremely difficult to accommodate, it's extremely costly, it's almost impossible. When it's that difficult, then yeah, maybe the employer can say that's what we call undue hardship. That's just too far. I don't have to go that far to accommodate it. But that's a very, very high standard. The employer is expected to understand that accommodation is not necessarily going to be easy. That, yeah, it may be difficult. It may cost some money to accommodate an employee, okay? So because of that, you have to ensure that your employer does what it's supposed to. Too many times, employers say, oh, no, that's just too difficult to accommodate, when it's not, when they're still legally required to accommodate. So if you need accommodation because of a medical condition, easy. Talk to your doctor. Get your doctor's note. Have your doctor say what your limitations are or what accommodation that you need. If your employer won't play ball, if they won't accommodate, call me. Usually, as soon as they hear from me, man, oh man, do they accommodate fast, okay? So keep that in mind. You have those rights. And to reach me, of course, very easy to do, employmentlawyer.ca to do that. Again, employmentlawyer.ca. See, that was the first question of the day. See how easy it is? Question asked, question answered. You can do the same thing. I see more questions have come in. I'm going to answer them. If you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you're here on my live stream session. The word live, right? I'm here live with you. This is not a recording. This is live. You can ask your question. I'll read it and I'll answer it. All right, let's continue. Next question from KHoop55. My girlfriend is returning from mat leave, and after 2-3 weeks of trying to figure out her return to work plan, her company said they no longer have a role. Should we be speaking to a lawyer? Yeah, absolutely. I thought mat leave was protected and returning to work and everything, and I've read, and they said that they have to provide a comparable job with the same pay. She was making $70,000 a year, but they offered her $2,000 as a payout for the last 2 weeks. Nonsense, illegal. The law is actually very straightforward when it comes to parental leave. You have to get the same job back with the same pay and the same terms you've had before. That's it. It's not more complicated than that. And if a company doesn't want to do that, man, oh man, they better have a good explanation, because it could be a human rights violation. It could be an employment standards violation. Depending on the severance, it could be a wrongful dismissal. In other words, it's illegal. So your employer must accommodate if you're coming back from a parental leave. It's not even accommodation. They have to take you back. So in this situation, KHoop55, yeah, your girlfriend is entitled to her job, same pay, same everything. And they can't just say, oh, too bad, we don't want to bring you back. That's illegal. And beyond that, she's probably, even if somehow they had a valid reason, let's say the plant burned down, they don't have a job, even then they would owe her a lot more than 2 weeks' pay. Okay, so this is a wrongful dismissal. So what she needs to do right now, not next month, now, reach me, okay? Have her connect with me as soon as possible. She can do that very easy. You see that address on the screen, employmentlawyer.ca. Again, employmentlawyer.ca. Want to help her. It's not going to be difficult to help her. And for anyone else out there, when you're coming back from a parental leave, same job, same pay. If not, if anything other than that happens, call me right away. Thanks for that question. Hopefully that makes sense. So in that respect, let's continue answering questions. Again, if you've just joined us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And that's the time for you to get your questions answered. Next question is from Joseph on Facebook. Joseph says, how many days off are you allowed before you have to provide a doctor's note? So generally speaking, it is up to your employer. Your employer has an obligation to be reasonable, okay? To ask for reasonable proof of your medical leave, or reasonable proof that you can't work. So if you're going to be off for 1 day, it probably be too much for your employer to say, I need a doctor's note. But if it becomes more extensive beyond a couple of days, it's reasonable to ask for a doctor's note. So it's not a hard line that says 2 days, 7 days. It's what's reasonable. If your employer says, I need a doctor's note after a day or two, in many cases, even though that may not be reasonable, if possible, give them that note, okay? It's just not worth getting into an argument, kind of a fight with your employer over that. Get that doctor's note if you can. If you cannot, if it's one of those things that, well, my doctor's away for the next 3 weeks, or I can't get an appointment for a few weeks, it is what it is. But if you can get a doctor's note, get that doctor's note. Certainly for anything more extensive, a lengthier absence beyond just a few days, absolutely you need a doctor's note. If you need accommodation, you always need a doctor's note. You're never going to be able to tell your employer, hey, employer, because of my medical condition, I need to work part-time. That's not good enough. That's not going to trigger the duty to accommodate. What's going to trigger a duty to accommodate is your doctor saying that. If your doctor says, for medical reasons, this individual has to work part-time, that then means your employer must accommodate. So hopefully that makes sense. If you're dealing with an employer that's not helping you or making unreasonable demands, I'm here, not going anywhere. You can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, another question answered. More questions are coming in. I've just seen them. I'm going to answer them right now. But if you've just logged on here and you're wondering what this is, what are you watching? Well, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP, and this is my live stream sessions when I take your questions about employment law, about your job, about your workplace rights, and I answer them. So ask the questions. You still have time. Okay, you got plenty of time. I'm still here for a while longer. So if you ask your question now, I guarantee you will get an answer. All right, so let's continue answering questions. Next question from Turkey Ninja. Okay, Turkey Ninja. My supervisor told me at the end of the shift that if I missed the scheduled time for my unpaid lunch, I would be required to work through it. I'm 90% sure this is illegal. But what are my next steps? So yes, you are required, depending on how long your shift is, to get an unpaid lunch, and you cannot be made to work through it. So your employer must provide you that lunch, and it's not an option. It's illegal to say, too bad, because whatever happened, you work through your lunch and you don't get it. No. Now, depending on your province, certain shifts require that. If it was a 3-hour shift, you may not get that. But for longer shifts, absolutely, you have to get an unpaid lunch. So it is illegal. And for that, this is the type of thing, if your employer will do that, if they try to take away the lunch, you can absolutely file a complaint with the Ministry of Labor, and that will be the recourse that's available for you there. So thank you for that, Turkey Ninja. All right, let's continue answering questions. Ask yours as well if you've just joined me. Don't be bashful. You got time. You can get answers. You can feel better about your workplace situation. Just ask the question. Carlos has our next question. Carlos is joining us on Facebook. I'm on an organ transplant list working from home. Can my employer let me go during waiting period or after surgery? No. Well, certainly they can't let you go because of that, because you're on that list and because you can't work from the office. If it's completely unrelated, then they could with severance. So let's say they shut down the department and they let everyone go. Well, if you're in that department, they would be allowed to let you go as well. But they can't let you go because they don't want you to work from home anymore. That would be illegal. All right. You're entitled to a job protected leave or to be accommodated. Either way, you cannot be let go. If your employer does anything to you, you're talking to the guy that can help you. Just go to employmentlawyer.ca. You can reach me that way, and we'll figure it out. But no, you cannot be let go. Make sure that they know what you're doing. Make sure they have an update as to timeline. Make sure they have a doctor's note. Make sure they have all that information. So they can't say, all right, we didn't know. We thought you just didn't want to work. So make sure they have that information. And if they do anything to you, call me, email me, and all that contact information is employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's see. Let's continue answering questions. All right, Miss Drea. Miss Drea on YouTube has our next question. We have long-term employees with signed offer letters from 10 years ago. How should we go about getting them to sign new documents that have modern-day termination clauses in there? Very good question, Ms. Drea. So yes, I can guarantee you that your employment agreement from 10 years ago, probably not worth the paper it's written on, okay? A lot of changes in the law. So if you want to have a termination clause, which is a term that speaks to the termination entitlements of an employee, they need to sign a new employment agreement. So here's what you can do in that situation. In order for that to be legal, in order for you to have someone sign a new agreement and to make that enforceable, you have to give them something in return for signing. So here's what I mean. It could be a one-time signing bonus. It doesn't have to be much, but some signing bonus. It could be a pay raise. It could be extra vacation, something. It doesn't have to be anything big, but something that they wouldn't otherwise get. It can even be, you know what, this year, if you sign it, you'll get an extra day's vacation. It's as simple as that. You can do that. You have to give them something in return. But if they come to you and say, oh, thank you, but we're not going to do it. So I appreciate you offering me a signing bonus, but I'm not going to sign this. You can't make them, all right? You can't force them, or you can't fire them for cause for refusing. So a good time to do that is, let's say you're giving someone a pay increase or a promotion. So say, okay, we're giving you a promotion. This promotion comes with this new employment agreement. or we're giving you a pay raise for this year. This pay raise comes with an employment agreement. In most cases, that employee is going to sign it because they want the pay raise or the promotion. But if they ultimately refuse, you don't have to give them the pay raise, you don't have to give them the promotion, but you can fire them for cause for refusing. So hopefully that makes sense. If I'm going to put a different hat on, so this, what I just said was from the employer's perspective. If I were to talk about it from the employee's perspective, well, my answer is going to be, if your employer comes to you once you're already employed and asks you to sign a new employment agreement, don't do it. All right. It's bad news. This termination clause that we've been talking about, if you sign this agreement, could cost you at some point tens of thousands of dollars, maybe more. So don't do that. It's never good news. Certainly if you're an employee and your employer wants you to sign a new employment agreement out of the blue, don't sign anything without me seeing it first. Okay. Send it to me, email it to me. Let me review it. Let me tell you what this all means. And of course, you can find all my contact information at employmentlawyer.ca. Now, I've just been talking about severance, and I've been talking about what severance someone is owed. Well, let me tell you what you can do if you want to find out for yourself. What is severance? How much severance should you be getting if you just lost your job or if you're worried about losing your job? How do you find out? So easy. Well, you can call me, but the other thing you can do anytime is you simply go to pocketemploymentlawyer.ca. You see that address on the screen, pocketemploymentlawyer.ca. And when you're there, you just click on the severance calculator. That's it. The severance calculator does what the name suggests. It calculates and tells you how much severance you're owed. It takes about 30 seconds to go through it. You answer 3 questions, and it's going to tell you you're owed 10-month severance, 15-month severance, whatever the answer is. It's easy to use. It's anonymous. It's free, 100% free, by the way. You couldn't put a credit card number in if you wanted to. Nothing like that. And you'll be surprised by the number there. You'll be surprised because so many people think that if they lose their job, they're owed a week per year of service or 2 weeks per year of service. Not at all. For most people, you're owed significantly more than that. Okay, significantly more. You'll be shocked, frankly. So check it out. It's free, it's anonymous, it's accurate, it's all those good things. Go to pocketemploymentlawyer.ca, use the severance calculator, and when you're there, if you want to, you can also contact me directly from the severance calculator. So great tool to use. Over 2.5 million people across Canada have used it already. Again, pocketemploymentlawyer.ca. All right, let's see. More questions to be answered. By God, if you haven't asked your question, by the way, what are you waiting for? Now's the time. Don't wait till I'm saying my goodbyes and then it's too late. You have still time, plenty of time, in fact, to get your question answered. So ask it, have me help you, get answers, and you can do that right now. All right, let's see. Next question, also from YouTube, from Boss C. I'm in the food industry and have a medical condition that I disclosed to my manager. She has shared my condition with colleagues. Can I do anything about it? Well, it's certainly inappropriate, okay? You have a right to your privacy. And by the way, you don't even have to disclose your medical condition to your manager. They don't have a right to know. They have a right to know if you have limitations. They have a right to know if you need accommodation, but they don't have to know the right to know the specifics of your medical condition or what condition you have. But in this case, you told your employer this, and they shared it with someone else. Not appropriate, okay? Not appropriate at all. Now, the only thing you can do about it, other than to speak to your manager and tell her, listen, this is not cool, don't do this again, you can take legal action. Okay, this could be a constructive dismissal. It could be a breach of privacy legislation. I don't know that you want to do that. If you want to pursue it that way, we can talk about it. Okay, I'm happy to connect with you and have that discussion. I think most people in this situation are going to be very unhappy, but they're probably not going to want to take legal action. So if you're not, talk to your manager, tell her that's not okay. This is not something that I want you to ever do again. And hopefully your manager respects that. I'm sure she will. But if you want to take legal action for this breach of privacy, you can. Potentially, this could allow you to treat your employment as being constructively dismissed, potentially. So we can have that chat. And to reach me if you want, employmentlawyer.ca. Again, employmentlawyer.ca. Phone numbers there, email addresses there. All the information that you want is right there to connect with me. All right. By the way, for the last 10 minutes or so, if you've just joined us and you're wondering again, what is this thing? What is this guy talking about? Well, I'm Lior Samfiru. They call me the employment lawyer. I'm with Samfiru, Tumarkin LLP. My firm, again, is across Ontario, BC, and Alberta. And this is my live stream session when I get to give you information about your legal rights, answer your questions, and tell you what the law can do for you. This session is for you. It's a live session for you to make sure that you feel better about the workplace rights. So let's continue answering questions. In the meantime, you can ask yours. All right, North Star, love that name, has a question. I'm exploring a new role with my current employer. The offer for the new role has a termination clause. We've just been talking about that, right? That was not included in my offer 9 years ago. It involves agreeing to statutory minimums in the event of termination for any cause. Assuming I stay with the company, it seems like they would be able to terminate with minimal severance. Is this common practice now? It's not, and you should not agree to it. And I know you want that new job, but if the only way they'll give you that new job is if you sign this new agreement, it's not worth doing. Let me give you an example. It could be a situation where if you were to lose your job today, you could be owed, I don't know, a year's severance. Could be much more, but let's say it's a year. If you sign that employment agreement and the next day they terminate you, that a year now becomes 8 weeks. So think about the tens of thousands of dollars you would have lost. And that gap, that difference could be even more than what I've just said. Unless they're giving you a massive pay increase, they're tripling your salary or something, it's probably not worth it. And you can say, I want the job, I'm fine with it, I'm excited, but I can't agree to this. And if they refuse to change that, you know that you've made the right decision. Because if they weren't really looking to let you go and save a bunch of money, they're not going to care that they'll change that termination clause. If they won't, you got to be very worried. So this is exactly what we were talking about a minute ago. Be smart, do the right thing. Do not sign something that could limit you and cost you tens and tens of thousands of dollars. It's not worth it just for a new job, in my humble opinion. Okay? Happy to review that employment agreement with you. Happy to help you, but at least you know. Okay? But don't sign before you have me see it. Great question, and man, what an important thing to remember. I've said it before, but I think it bears repeating. You have a job, you've been working for a while for the company, everything is fine. Then one day, the employer says, hey, you know what? We just need you to sign a new employment agreement. Never a good news. That's never good news. That's never something that should be taken lightly. I can almost guarantee you that in that new employment agreement that your employer just wants you to sign, there's going to be plenty of terms that are not favorable. For example, something that limits your future severance, cost you tens of thousands of dollars. Something that maybe allows the company to put you on a temporary layoff. They don't have a right to do that unless you sign an employment agreement that gives them that right. Something that allows the company to change your pay, your job, your hours of work. Again, those are things that the company is not allowed to do. They're not allowed to make those changes unless you sign an employment agreement that gives them that power. All right, so you have to be smart about it. Don't take it lightly. Let me see it. If your employer wants you to sign a new employment agreement, take a step back. Send me a copy. Let me read it. Let me tell you what it does and what it doesn't do, and we can talk about how to respond to your employer as well. And to reach me and my team, very, very easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. All right, great. Let's continue answering questions. I see some more have come in. Steve has our next question. I was let go from my contract 2 months before the contract ended. It was a 3-year contract. Am I owed any sort of severance for this? So if you're let go before the contract ends, the general rule is that you have to get paid till the end of that contract. So Steve, if you were let go 2 months before the end of the contract, you have to get paid for those last 2 months. So right there's entitlements. Now, depending on the situation, depending on how the contract is drafted, you could even be entitled to more than that. So the best advice I'm going to be able to give you, call me, okay? Let me see the contract. Let me understand what happened. Let's have a chat. And you can reach me and get all my contact information through employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that question. Steve, I'm going to continue answering more questions. Waylon has our next question. My wife has worked with company A for 8 years as accounts receivable clerk. Her schedule is 8:30 to 4, Monday to Friday. Company A was bought by Company B. My wife was never given notice of a new job description. Now she's been told her training starts in 5 days for her new role. Her new role is completely different than her previous 8 years working. The hours are also 10 to 6:30 p.m. What are her options? Well, she could consider this potentially as a termination. So there's really only two options that she has. She can either accept this and continue working in this new role. Obviously, that's her right. Or she may be able to consider this a termination, a constructive dismissal, and get her full severance. Now, if she's been there for a total of about 8 years, depending on her age, I know she's an accounts receivable clerk, she could be owed anywhere from 8 to 12 months of severance. So option one, accept it, excuse me, and do what the company wants. Or option two, treat this as a termination. If she wants to go with the second option, the constructive dismissal option, she should not do anything without speaking to me first. And she can connect with me through employmentlawyer.ca. Again, employmentlawyer.ca. All right, let's continue answering questions. Last few questions, I want to get to them. All right, I'm going to do these fast, I think. Lisa, I've never been under contract for 12 and a half years, and my employer just handed me a contract. I've refused to sign the contract with my employer because my responsibilities have increased. The original contract had no signing bonus, and he recently contacted me with the same contract again, but it had a $2,000 signing bonus. But I still don't want to sign it. Am I doing the right thing? Well, Lisa, I can't say if you're doing the right thing without seeing the contract. I would need to see what it says. I can almost guarantee you that you don't want to sign that contract, but I need to see it. So, Lisa, you got to reach me through employmentlawyer.ca. Let me review the contract, and I can tell you whether it's okay, not okay to sign. 99%, it's not okay. You shouldn't sign it, and it's not worth the $2,000. But let me see it. Again, employmentlawyer.ca. All right. Atreyu Stan has our next question. When is an employer allowed to refuse to bring back an employee on mat leave? The only time is if the fact that you're not coming back has nothing at all to do with the parental leave. Now, if the department has shut down, if half the employees have been laid off, if something that's completely unrelated has happened, then yes, the employer can say, we're not going to bring you back, but we're going to pay you your full severance. In many cases, when the company says, oh, trust us, it's not related, it's nonsense. It's not the truth. But if it's true that it's unrelated, then and only then can the company refuse. But then, of course, they must pay full severance. And depending on how long the employee has been there, that could be as much as 2 years pay. So hopefully that makes sense. P. Chan has our next question. My accommodation request created a frustrated contract and is leading to termination. My doctor asked for a back office role due to mental health issues, and they told me to apply internally. I applied for 75 roles and no success. Do I have any recourse? Absolutely. They should have given you a role. Not to apply, they should have accommodated you. So it's not frustration if they have the ability to accommodate you. So this could be a human rights violation. This could be a wrongful dismissal. It's very likely not frustration. So you need to contact me as soon as possible, okay? Employmentlawyer.ca to contact me. Let's have that chat. Not legal, okay? You must be accommodated. Employmentlawyer.ca, P. Chan to connect with me. All right, let's do the last couple of questions here today. Bruno, next question. My employer laid me off without severance on my ROE. It says dismissal or suspension. I was working for 4 months. What are my rights? Well, Bruno, unless you did something terrible, unless you stole or hit somebody or committed fraud, you're owed severance. Even after 4 months, that severance could be a few months' pay. So what do? By now, I hope you know. You contact me, okay? Very easy to do that. Employmentlawyer.ca to contact me. Let me help you get that severance. Yes, even after 4 months, you're owed severance unless you did something terrible. Employmentlawyer.ca. Last question for the day from Ronald M. on YouTube. Can my employer refuse to pay out any unused vacation days? Absolutely not. They have to pay that out. Whether you leave the company, you're let go, or you need to get paid, they have to pay that. If they refuse, you can go to the Ministry of Labor. It's illegal. All right, guys. Wow. Lots of questions at the end. I think I answered them all. Thank you so much for joining me today. Always a pleasure to be here. Frankly, it's a privilege to be here. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. And I am going to be back next week. But don't wait until then. You can connect with me now if you want off air. Just go to employmentlawyer.ca. Thank you so much for being with me today. Have yourself a great rest of your day, and we'll talk to you soon. Bye now.